I want to start with this because I feel this is either agents are missing this in general because we're out there working. Some brokers are missing it, but the leadership inside of our real estate world isn't missing this, right? It's clear to them. It's everyone else that's missing this, and that's the DOJ hasn't even stepped in to say, hey, whether or not they're gonna be like, this looks good, or no, this doesn't look good, or here's kind of what we have to say. And this whole article, which is really great, lengthy, it pieces everything together for you. This and obviously John Riley put this together. This is where I want to start, and I want you to, Saul, I want you to summarize it for us because there's no way we're going to read all of this right now. So with that, I put it in the chat, everyone. Saul, where do we start with the DOJ jumping in and giving their 2 cents, or maybe just saying, scratch this whole thing, we hate it?
Well, so first, the summary that John put together. I hate to call it a summary because a summary is usually short, but
Yeah, this is not a summary. I found John. He's coming in.
so the summary that John put together covers many different things. There's not just one thing going on in the industry. There are multiple things going on, and some things are connected and some things aren't. And if you followed us here since we've been doing this, Tristan, and folks have been following along, we've included in different podcasts that we've done and webinars that we've done many different pieces. That's why John felt it was important to go back and start to bring it all together. Now, I say, what is the advantage to knowing about this? Well, remember, we always say that you need to differentiate yourself from your competition and that you need to have a compelling argument as to why people should use you as opposed to your competition, because real estate is this. This is maybe not a good phrase to use, but we used it before it became not a good phrase to use. And that is, real estate is a Me Too business. It's a Me Too business. And what that means is that I say, well, I sell real estate. Hey, I sell real estate too. Oh, well, what do you do to sell real estate? Well, I take listings. Me too. Well, I take out buyers. Me too. Well, I put listings in the MLS. Me too. I use lock boxes. Me too. I run ads. Me too. Real estate is a Me Too business. I charge X. Me too. See, that's part of the problem, right?
I see.
That it's a Me Too business. And so you need to be able to figure out ways to differentiate yourself from the competition. And that's way more than just saying, I'm different, I'm worth it. Hey, don't tell me to cut my commission. I'm different, I'm worth it. Well, how? What do you do that's different? What's your compelling argument? And what we've always said, John and I have said for years, is what part of your compelling argument should be your knowledge of the industry, particularly at a time when the industry is shifting and changing so much. We say it's a paradigm shift, it's a fundamental change. When that's taking place, your best tool is your knowledge and your ability to talk about things that people are reading about. They're hearing about it. Sellers might be saying, I've heard I don't have to pay commission, right? Buyers might have heard, I heard I have to pay. And maybe that's true, and maybe it's not, and maybe it's partially true. But how are you going to address that? How are you going to answer that unless you, the real estate professional, really know about what's going on in your business? Now, I'm not telling everybody they got to memorize this great treatise that John has put together, but
Yeah.
you say, what is this? John talks about all the different legal cases, all the different parameters, provides links to this, and the more you know about it, the better off you're going to be. How's that for a summary, John Riley?
Quite a summary. My summary was, I thought, rather brief compared to all of those cases that I had to read in order to excise out some of the stuff, which to me indicated that this is a signal from the Department of Justice as to where they're going. So basically, I was like CNN, I'm making a prediction, and my prediction is that sometime before the end of October, the DOJ will actually come out and tell us what their position is, that they will intervene either with a statement of interest or an amicus brief with the NAR settlement, and they will give us their take on where there's some strengths and where there's some weaknesses in that settlement. And this is going to have an impact because, you know, the final approval date for that NAR settlement is November 26th by Justice Bao. And so this is going to be very, very indicative of what's going to be happening with that. Now,
John,
of course, the justice doesn't have to listen to what the judge says. They can go on their own if they don't like the fact that the settlement was approved.
John, can you give us a quick, for those listening in, can you give us a quick real estate law lesson? And well, actually, it's just a law lesson, just two things. One, can you describe us what the difference between statement of interest and an amicus brief, just so that we understand what what it could mean?
Well, a statement of the interest is something in which if somebody is not even a party to a lawsuit, they can intervene. That's what they did in the MLS PIN case. They intervened there and gave us a little bit of these indicators of what their attitude is. An amicus brief generally, though, is where you're a party in the action and you're filing a brief that outlines what the position is, where they feel there's a conspiracy and maybe how it can be shown or proved, and where things fall short, like in the NAR settlement.
So an amicus brief, the word amicus is like friend, right? Like a me, right? So a friend of the court, right? Somebody comes in and helps the court make their decision. And somebody just asked a question about November 26th. And so
Frank, what's up, Frank?
Just to give you a little background, the August 19th was the day that NAR said all of the MLSs that want to be covered by this settlement. And this is a settlement in the Sitzer-Burnett case. And there are a lot of other cases, but this is in the Sitzer-Burnett case. And it also covers the Moeller case done at John in Illinois. And they came in and NAR said, August 19th, MLSs, you got to get all your ducks in line and you have to be in compliance with the 108-page settlement agreement. And the settlement remains in a proposed status until the judge says, okay, this is the final decision by the court. I, the judge, have finalized this, and that date is November 26th. So we're all operating under the assumption that the judge is going to approve the settlement as it currently stands. Now, what's happened and what we think could happen is that, and John made a prediction, and so did the attorneys at CMLS, at the Council of MLSs a couple weeks ago, which was held in Seattle this year, and I attended that. And the attorneys there indicated that they too believe that the Department of Justice will step in and have something to say about this. Now, as John indicated, it's up to the judge to decide whether or not the judge is going to make the proposed settlement the final settlement. And the DOJ can step in and the judge can either ignore it or can take the advice of the DOJ. But if, remember that butter commercial or some, don't try to fool Mother Nature, right? So,
yeah.
don't try. So if the DOJ steps in and says, and they've made indication, they've said, we like the settlement as far as it goes, but we don't think it goes far enough. And we think that there shouldn't be any offers of compensation anywhere. The settlement says no offers of compensation on the MLS. So people are figuring out how to do offers of compensation off the MLS. People are trying to figure out ways to disguise compensation, calling it concessions. And so while these things are going on, we know the DOJ, the Department of Justice, has said, hey, you're headed in the right direction, but we don't really think it's gone far enough. And what the attorneys at CMLS said is they believe the DOJ will step in prior to November 26th. Why prior to November 26th? Because if the judge approves it, it's like it would be hard for the DOJ to step in after that and say, oh, wait a minute, we didn't approve of that. And we would like you to consider us. So if the DOJ wants the judge to consider their position prior to making any final rendering, that would take place prior to November 26th. And that's what John's saying. He expects the DOJ to step in and say whatever it is they're going to say. Now, from where we sit, we think that they wouldn't step in and say, oh, you go way too far.
What? No way. That's good. I like that. No, that's not going to happen. What? So then, in this case, John or Saul, what would they step in and say? Like, what would they say? Hey guys, listen, it's a good try, but we really need to separate the commission even further. Like, you can't even talk about this or what.
Well,
where are we heading?
one possibility is they could actually come in and they say, you know, that's a good try. Why don't you guys just reconvene and have another more detailed meeting and spell out some of the things with better clarity? And that way we'll be perhaps in favor of it. So that's one thing, is to basically add for a reconvening. And that reconvening could lead to kind of a new settlement agreement and approval. So that's a possibility that some people have raised.
Well, yeah, the DOJ could step in and say, if you don't do it, we're going to start pursuing other things we don't like that you're doing. So you want to consider this option. Another thing is, we also know, we hear this, that the DOJ doesn't like the idea of pre-knowledge that the seller will pay anything. Forget whether you think it's a good idea, a bad idea. The DOJ believes that it's not a good idea for the buyer's representative or the buyer to know ahead of time, because that can lead to issues the DOJ doesn't like. So they might come in and say, we believe that you need to change this settlement and you need to eliminate any pre-knowledge of any compensation or concession or commission that the seller is willing to pay. And if the buyer wants any type of compensation, consideration, whatever C word you want to call it, that they ask for it in the offer. Could be
You know, the
something like
DOJ has also asked for some type of an injunction preventing even the seller from making that pre-knowledge offer. And of course, that raises some constitutional questions about trying to muzzle the seller themselves. But that was one of the things that was also mentioned by a DOJ attorney.
So yeah, we're just waiting for the DOJ to step in. We're all guessing. Now, here's what else has happened. Everybody is guessing as to really what's the best practices under this nebulous settlement agreement. And so people are making stuff up. Oh, you just text or you call the listing agent and you ask them. And then other people say, no, you can't do that. Oh, you put a sign writer on the sign and you say seller willing to compensate or willing to offer commission. And then other people say, no, you can't do that. And then some people say, oh, you put a little note in the lockbox that says seller willing to compensate buyer's agent. And then other people say, no, you can't do that. People are just making this up. They don't know because they're not going to know until this is final. And all we have to go on, as we've talked about paragraph 58, Tristan, are those 13 points. And what is evident and clear is that you cannot offer compensation through the MLS. It doesn't say you can't do it off the MLS, but remember, the parties to the settlement are the plaintiffs and the defendants, and the DOJ is not a party. They're just the government, right? And we're still waiting to see how much effort they're willing to take to upset the current apple cart.
And you know, the DOJ currently is in a lawsuit against the National Association of Realtors. You remember all the hassle and delays with the suit about the withdrawal of commission? Well, the Court of Appeals has basically said, no, that should go ahead. So they are currently going ahead. Those administrative subpoenas demanding data and information from the NAR have been issued and responded to, and the stuff that I think the DOJ attorney, Jessica Leal, was saying, we're examining these now and we'll have something by the end of October. So that's why we're kind of making this projection, but it is a projection.
Well, yeah, and here's something else. I see all these interesting comments. People say, well, that's not fair. Or why would somebody work for free? Or I don't agree with that. Well, who cares what you agree with? You're barking up the wrong tree. We don't care what you think is fair. We, the Department of Justice, we don't care that antitrust law is not normal law. And you're talking, and it's interesting too, as people in the real estate industry, we've always been very careful about the way we deal with antitrust, because we don't want to be accused of antitrust. The antitrust lawyers are very expensive. We know we're dealing with the Department of Justice. People say, well, who was going to work for free? Well, hopefully nobody. And that's what the DOJ says. They're not saying you have to work for free. They're saying you got to get the buyer to pay you, or you got to get the buyer to ask the seller to pay you. And nobody's asking you to work for free. You just got to figure out new ways to make that compensation flow to you. And it is a new way, right? It is a paradigm shift. It's a fundamental change because the MLS has made it possible for people not to get contracts with buyers. You didn't need to. All you need to do is join the MLS, and you are guaranteed you're going to get paid through the MLS. Well, the DOJ has said, we don't like that model. We've been trying to change that for years. So now you have to change your MLS and take the offer of compensation out of the MLS. So far, we haven't been told that you can't be paid anything. You just have to figure out new ways to be paid for what you do. Now, be alerted to the fact that there are entities and people in the background that would love to see the industry completely disrupted and a new model emerge that is completely different than what we have today. And so we need to pay attention to this. We need to be watching for, pre-November 26th, and we need to be able to move nimbly.
One thing the DOJ would like about the NAR settlement agreement is the fact that it's based on the fact that there needs to be negotiation with all of the parties throughout the transaction. In other words, the listing agent has to negotiate with the seller. The buyer's agent now has to negotiate with the buyer's agent. And then the buyer and the seller have to negotiate at the purchase stage. But what the industry isn't going to like, the attitude now coming back from the DOJ, is that they're focused on protecting the competition. And all of these cases are about protecting competition in the marketplace.
So I want to go back to the synopsis that you put together on the data advocate. And all these things that we're talking about, John's addressed them based on the litigation and what people have said about the litigation. So if you want to read the actual documents, you want to read a synopsis by a retired attorney, and that's John, and the actual cases and references to it, they're all there in that document. It was quite a piece of work to have to go through and put it together.
John, how long did that take you? Like 2 years? You're ongoing, maybe 2.5?
Oh, I think about, just like the plumber, it took me about 20 years.
It's a good, dude,
to learn how to turn the screw.
When you sent that to us, I thought it was going to be I was telling Saul, I thought it was going to be short. So I left it to read it this morning. And then I was like, oh crap, I better settle in.
No, that's for your leisure weekend reading, Tristan.
Holy cow, man. That's great. All right. So we've set the tone, but we're quarreling amongst ourselves. Like the industry is not like seeing eye to eye with themselves. We're fighting over clear cooperation policy, which, Saul, I know you've got a different name, the original name for it, right? But what the hell is going on there? Like,
well, that's interesting, Tristan. Actually, it's the DOJ. And then you got interested parties, I think self-serving interested parties, or interested parties that really don't really understand what clear cooperation, where it came from. And so, yes, I have another name for it. It's called mandatory submission. And so I've been licensed to sell real estate in California since 1975. And when I joined the MLS in 1975, there was this rule that said you have to, when you get a listing, you have to put it into the MLS. And everybody had to follow that rule. That's what makes the MLS powerful, is the fact that everybody has to put their listings in the MLS. Now, there always has been this caveat that said, maybe you have a seller that doesn't want to put their listing in the MLS, so you can have an office exclusive. But when you take a listing, there's a time frame and you have to submit that listing to the MLS. And what happens then is, I know, Tristan, you're going to put your good listings and your bad listings in. And I know John Riley is going to put his good listings and his bad listings. And I know I'm going to put my good listings and my bad listings. And why? Because if I don't, they're going to kick me out of the MLS. And so once we get used to the fact that we're all putting our good and bad listings into a pool of available properties for sale, and then a summary of all the sold properties, once we all kind of got used to that, it became a great tool, because now sellers got a lot more exposure, because every person in town would be in a position to know their property was for sale and to bring a buyer in. So there's an opportunity for more exposure for the seller. There's an opportunity for buyers to see more property working with one agent. They could see everything that was in town. Agents weren't restricted to just the properties they had listed. They now knew that they could show any property that any broker in town had listed. Listing agents, their marketing changed a little bit, because now every anybody who represented a buyer, or anybody who could bring a buyer, could get paid. So this idea of mandatory submission is an underlying factor to the success of MLS. Mandatory submission. Well, what happened in 2018, 2019, people started thinking, because the market was going crazy. Remember that? You put a sign in the ground, you get 20 offers within 20 hours. All of them are 20% over the listed price, and people are waiving inspections, right? It's
Yep.
like, well, shoot, here's my chance to make some money. So I don't want to put it in the MLS. I'm going to withhold this listing from the MLS. I'm going to try to sell it myself. I'm going to sell it to my own network of people. NAR, realizing that mandatory submission is very integral to the success of MLS, they came out and they said, okay, you got to put your listing in. They tried to compromise. You got to put your listing in. You got to put it in within 24 hours. We're going to call it clear cooperation. In my mind, the driving force is what? Mandatory submission. You got to put your listing in the MLS. You can't market it for sale, right? We created all these rules. We created coming soon. So now, because of the restriction in inventory and the fact that people wanted to sell their own listings, they wanted to withhold it from the MLS. And so NAR said, we want a rule that reiterates the fact that you've got to put your listing in the MLS. And so that's where clear cooperation came from. Agree or disagree, that's where it came from.
Got it. All right. So now we currently have it in place, and now you have brokerages, CEOs of brokerages. Rifkin's pretty much saying, hey, it's not good for us. Mauricio Umansky, the agency, is saying it's not good for us. And then you have the opposite side of this, which, I mean, I never agree with the CEO of Redfin, but I agreed with him on this one, where he's saying, hey, clear cooperation may not be the best thing, but it's good for what it is right now until we change it, right? And I was like, okay, I can agree with that.
Yeah.
And then you have other people saying it's a good thing. You guys agree with me. There are some things that could change on it to make it amazing, but if we remove it completely, it's going to be another disaster. Explain to me why.
Well, so if you remove it, what you remove is mandatory submission, where you don't have to put your listings in right away. So if I don't have to put my listings in, I'm going to hold them and see if I can sell them myself. Now, people will tell me, so those people who say that mandatory submission is not a good idea, I believe their argument is very self-serving, and they've got their own agendas. And so you mentioned somebody, and I won't mention his name, but I've listened to him speak, really self-serving. The idea is, if in fact the MLS is weakened and people aren't putting listings in the MLS, and if I have a lot of agents that work for me and we're getting listings, we've got a big chunk of listings in any marketplace. We can say to people, we've got listings that you can't get in the MLS. We've got listings that you can't get from our competitors. The only place you can get them is from us. So you need to come to us. And so buyers will come to them. And when buyers come from them, they'll say, agents, if you want to be in a place where you've got more listings to sell, you need to hang your license with us. You need to now and so that's the pitch. It's interesting to me is, well, what if how are you going to convince a seller not to put their listing in the MLS? You tell me. People aren't asking the right question. You tell me why it's not in the seller's best interest to get as much exposure on their property as possible. And while Rifkin might say, he might come out and say, well, we think they should have more choice. You think that they really understand how the market works? You think that sellers really are giving informed consent? And if you really explain to them that the ability for people to see their property for sale is restricted, that's in the best interest. And then something else, if in fact they're all in-house listings, then what you're going to end up with in the best case scenario is dual agency. And dual agency is limited representation. Do you believe that restricting the view of your property from people who might be willing to bring you more offers and limited representation is in the best interest of the consumer? I'm all ears. I want to know why, Compass, you believe that that's in the best interest of the seller. Well, they should have choice. I've been an advocate of seller choice and buyer choice for years. I've just haven't been convinced that withholding it from the pool that lets everybody know it's available is in the best interest of the seller, and it's certainly not in the best interest of buyers. But if you're a broker and you've got enough agents working for you and you can have a pool of listings and you're the only one that's offering them, then
Listen,
right?
that makes sense at that point, right? It's like, hey, let's do this. John, what do you think?
Well, actually, I just received a message from an agent that said, I currently have access to over 50 off-market listings in coastal New York. You will not see these listings on the MLS, Redfin, or Zillow. It's called private exclusive, and I have access nationwide. That's what I'm afraid you're going to see from agents who are taking advantage of that situation.
John, that's just the beginning. Like,
Yeah.
if we get rid of this and don't replace it with something that's, maybe better, right? But if we get rid of this, that opens up the door for lawsuits, like more crazy lawsuits.
Well,
like
now people could accuse you of not sharing with them based on a fair housing violation, right? So it opens up I agree with Glenn Kelman of Redfin on this one as well.
Listen, it was hard for me to say that, Saul, but I was like, oh, I agree.
Yeah, I agree with him.
All right. So with that, really quick, when it comes to the current CCP, what is it? Clear Cooperation Policy, sellers can still opt out of putting it into the MLS. It's not like you're never going to be able to say, hey, I don't want it in the MLS right now. Let's not put it in there. Let's remove it. And let's do what you want to do, brokerage, not put it in, right? That is the case.
Yeah, with an office exclusive. But I go back to, why would a seller say that? Now, I get it. Some people would share.
Yeah.
Might not want people to know.
Yeah, in some rare cases, it happens, right?
Yeah,
But
you think if you're share, how many people are there that would buy your house? Right? So you don't need this maximum kind of exposure that you need for most houses. But for most people, it makes sense to maximize the exposure. We used to say distribution trumps destination. Distribution, you want to get it out there. That's why you'd run, when it used to be in the old days, you take a listing, you run an ad in the paper, right? You run ads. The more a seller would want to know, how are you going to market this? How are you going to let people know that my property's for sale? And that's what the MLS does. And so to take away this mandatory submission, or call it clear cooperation, and yeah, there are flaws in it for sure. You know why? It was a compromise.
I remember.
And so now the DOJ, what they've said is they've come in and said, and I can't remember where I read it, John, you might remember. They said, number one, we want to get rid of office exclusive. There shouldn't be an office exclusive. I agree. I think the office exclusive should go away as well. Now, they also say maybe you should give people 60 days to put it in the MLS. Well, I don't know about your market, but in my market, property is going to be sold in 60 days. And so that destroys the matter of fact, if you say you don't have to put it in for 60 days, in fact, what you're doing is giving everybody an office exclusive.
I know. And somebody in the comments said, if this goes away, like goodbye small brokerages, like, right? It's
Yeah,
like
it's not in my mind. I fail to see the benefit to most owners. I fail to see the benefit to most buyers. I fail to see the benefit that people who work with buyers, and I fail to see the benefit, except for some firms that have a different strategy for recruiting and for generating leads, right? And then way above real conspiracy theory stuff, way in the background, there might be other forces at play that would like to see a major change to the way that we list and sell real estate. And we will get into that in another
But
conversation.
listen, we touched on it lightly in a previous episode, I remember. And I was like, you guys opened my eyes on that one. All right, so let's wrap this up and just remind everyone that we have a ton of uncertainty, everyone. And just like COVID, we had a ton of uncertainty. And I think, and I know you guys believe this too, there's a lot of opportunity out there for the agents that are working, the brokerages that are working, that are creating from all of this uncertainty, creating clarity for their clients. Because at the end of the day, the client wants what? The best price for the home in the least amount of time with the least amount of issues. That's it. And you can create that clarity. This is why you're here listening in. So you're like, got it. I have an idea as to what might happen. Let's wait in this uncertain world, but none of that's going to go to my client because I'm going to study this. John made this great book that he called an article that you can all read, which I'm going to go in and highlight more. So I'm prepared because our job is to be prepared. So Saul, John, anything in closing here?
I would just add, and you hit on it, Tristan, and that is that there's a period of time between the discovery of anything and when everybody knows about it. And that period of time is called lag. And that's where we are right now. We got this new world. We're figuring out, we're trying to navigate. There's a lot of uncertainty, but with uncertainty comes opportunity.
That's it.
Right. And so the best thing you can do is be informed right now. And that's something that you would differentiate you from most of the people that I know that sell real estate that only have an inkling of what's going on.
It's true. That's true. Everyone listening in right now, you're already way above what most people even understand. So this is why we're doing this every 2 weeks. This is why Saul, John, and I created this specifically because we knew what was going to happen, and no one's touching on it on a consistent scale over a longer period of time. So we're going to take you through whatever the DOJ comes in and says. We're going to take you through that, the aftermath, and then probably whatever happens with the CCP. And if John, Saul, and myself are right, and the DOJ comes in, but then punts it to next year, this is going to last a little bit longer than you anticipated. So we don't know. We'll see though. Saul, John, thanks again, guys.
And I will promise to do a better job summarizing my summaries.
No, dude, I was joking. I loved it. I printed it out.
Okay.
I'm going to be highlighting it. And I put it in. Yes, definitely. And Saul, next time, let's talk about, so Saul went to Europe, Italy, I think it was, and he talked about how the MLS is trying to form over there for Europe, I guess. So we're going to go.
The world.
The world.
An international MLS forum. Was the second year. The first one last year I went to was in Paris. This one was in Milan. Next year's in Toronto. And it's fascinating because they don't have MLS outside of North America, really. And they've got all kinds of problems and all kinds of issues, and they all want They
Yes.
want MLS, but they want it without compensating each other. So here you got MLS conversations in Europe without compensation, and here we got MLS conversations with compensation. It's
That-
fascinating. There's even the representative from Mongolia. Now, who'd have thought? Because I'd have never thought. I'm thinking about, gosh, I'm seeing how they list and sell real estate in Mongolia. So MLS is an international concept now, and we'll talk about it next time.
Let's start with the negatives and then go into the positives. All
You
right.
got it.
You got it.
John, keep on writing awesome stuff, man. Thank you. Saul, thank you so much. Bye, everyone.